Thank you for joining us today. Before we start the webinar, I would like to acknowledge the traditional custodians of the land that we are meeting on today and the lands that you are all on across Australia. I am joining from Camaragal country today in Sydney, and I acknowledge elders past and present. And also we like to acknowledge that Aboriginal people are the first and obviously continuing educators on this land. So thank you. So this is what we're going to be covering in the webinar today. I'm going to be talking very quickly about Legal Aid New South Wales, where then I'm going to be handing over to Helen to talk about criminal law words, so words you might come across in court when you're doing interpreting work in court, some criminal law processes, and also legal documents. General words used in different criminal law areas and different offences. We're also going to be talking about types of sentences that you might hear in court, and we'll also talk about where to get help with legal words. So that's basically what we're going to be talking about today. If you do have any questions as we go, please put them in the Q&A. We got a lot of questions in advance when you registered about different words people wanted to know. So thank you very much for sending those through. We have incorporated those into the session. So just please be patient. We will probably get to the words you asked. But if you have any other questions, please do put them in the Q&A. As I mentioned, we have a lot of people online today, so we will try and get to all the questions. You will also get an email after the webinar, which will have links to resources and information. So if we don't get to all your questions today, we should be able to answer you in the email. So very briefly, so what do we do at Legal Aid New South Wales? So we give legal advice to some people. So you might be asked to do some interpreting work in an advice session. So that's something we do a lot more over the phone these days since COVID, but also might be face-to-face at an outreach, so at like a community centre, or might be at court. So we do duty services at court. So that's when a lawyer is at court to talk to people who come in on the day. Minor assistance might be like helping a client write a letter if they're not able to do that or something like that. So that's some of the work we do. And then we also have what's called a grant of legal aid. So if a legal aid lawyer is representing someone in court for a hearing or a trial, then they might have applied for a grant of legal aid and had to be eligible. And also we do community legal education, which is like what we're doing today. But also many of you might want more information about, for example, in New South Wales, there's a new law on coercive control that's starting soon. So we will do like a webinar specifically about that issue. So that's what we mean by community legal education. And I'll tell you later on how to find and register for those other sessions, which you're welcome to join us at. Legal Aid has a website, which is, I don't know, a year or so old now, which is a really good website with lots of information and also some translated content. So if you can see the screen now, that's the Legal Aid New South Wales website address. And you can see there's some languages that you can select to have the website in, which might be relevant to some of you online today. Not all languages, unfortunately, but please do have a look at that, which might help with what we're talking about today. There's also under ways to get help on the Legal Aid New South Wales website. You can see we've circled there's a section on legal words, so like a little glossary. So that might be something else to have a look at today, as well as publications and resources, which has some translated publications. And there's also, you can see on the screen there, it says community legal education. So that's one place you can have a look to register for what's coming up with other community legal education we're doing. I just wanted to put this slide up. So this slide says, who do we help? So this is from our annual report last year. and you can see that interpreters were required in 3.6% of our, for us, 3.6% of our clients. So, and that might not sound like a very high percentage, but it does amount to a lot of clients who you help us with. So just wanted to say it's a very significant part of the work we do is working with interpreters. So yep, thank you again for the work you do. So that's a very brief outline about Legal Aid New South Wales. And what I'm going to do now is hand over to Helen, who can introduce herself. She's a very, very experienced criminal lawyer, and to talk, let's just dive straight into our section on criminal law words. Thank you very much, Helen.
Thank you, Natalie, and thank you, everybody, for joining us this morning. Just as Natalie said, we really appreciate the work that you do as interpreters and those of you that also translate documents for us. We really appreciate that because you help us lawyers to communicate with our clients and help our clients communicate with us in conferences and us giving advice to our clients and also in the courtroom. It's essential and it's invaluable. So thank you very much. It's not an easy job. I think it's a very difficult job that you do and a very big responsibility because what you do is so important. So thank you very much. We really respect the job that you do. So yes, I've been at Legal Aid for a long time. I specialise in criminal law, so I do not practice civil law or family law. But sometimes there's some overlap with crime, family and civil law, like mental health issues, some domestic violence and apprehended violence orders. There's some crossover between different areas of law, but my specialisation is criminal law. So that's what we're here to talk today about, criminal law words. Every charge in New South Wales starts in the local court. Now, those of you who practice in Victoria, they don't call it local court, but in New South Wales, the lowest court or the court where every charge starts is called the local court. So it doesn't matter how serious or less serious it is, everything will start in the local court. And then some matters go up to the district court, like armed robbery, sexual assault, supply of commercial quantity of drugs, that sort of thing will go to district court. Murder matters and terrorism matters, for example, or big tax fraud matters will go to Supreme Court. Above those courts is the Court of Criminal Appeal, and that's 3 judges listening to appeals against conviction if somebody's been found guilty by a jury in the district court, or appealing the severity of their sentence, the length of their sentence, their punishment. The Court of Criminal Appeal will hear those appeals. And above that is the High Court of Australia. And so the High Court only listens to a few appeals every year from across the country. So every state and territory may send matters to the High Court of Australia, but it's very difficult to get permission to go to that court. We have statute law and common law. Statute law are legislation or laws or pieces of legislation which are created by politicians in the Parliament, in the New South Wales Parliament, or the Commonwealth. The federal Parliament will create Commonwealth laws which will apply across Australia, like Migration Act and Commonwealth Criminal Code. They're Commonwealth laws that will apply in every state or territory in Australia, but New South Wales Crimes Act is a piece of legislation passed by the New South Wales politicians or Parliament, and the judges in the courts or magistrates in the courts refer to and follow the legislation. It will have maximum penalties, like Crimes Act, Bail Act. So when people are applying for bail, we follow the Bail Act. Drugs Misuse and Trafficking Act, drug legislation, or Criminal Procedure Act. Common law is New South Wales or states of Australia borrowed law from England, from the United Kingdom, called the common law, and judges make common law. They follow other cases, they make precedents, they follow other judgments, they follow those precedents. So they can also create common law. And our tradition is based on the English common law system. But since the New South Wales has been a state, Parliament has made its own laws, and that's the statute law. So hopefully that explains a bit of a difference between statute law and common law. The criminal process starts with police arresting a person. So when a person is arrested by police, they are not free to leave the police custody, so to speak. They'll be taken to the police station and they can participate in an interview. And as an interpreter, you might be called on the telephone, or you might be asked to attend a police station in person to read out or explain a person's rights. Police give the person a piece of paper, and you might have to interpret what is on that piece of paper about their rights, their right to silence, their right to speak to a lawyer. Some people the right to telephone a person. So there's a series of rights which police must explain to a person. And then as the interpreter, you may also be asked to attend the police interview with somebody. So if somebody agrees to participate in an interview with police, and it should be known that there is a right to silence, they do not have to participate in that interview, but if they do, then you as interpreter may be required to sit in the interview. It's video recorded, audio recorded, and then that can become evidence in the case. So person may be interviewed or not, and police will decide what charges they are going to lay against the person. And police process the paperwork, and then police decide whether they are going to release somebody on bail after they have been charged with an offence or a number of offences, or police remand that person in custody. They hold that person. The person may not be released on bail. They may not be free to leave the police station. Either way, the person, if they're granted bail, they'll be given a future court date that they must go to court and attend court for the first occasion. It'll be a local court appearance. Or if they are held in custody, if they're remanded in custody, they will be taken to the police station either that same day or the next morning if they're arrested overnight, and they go to the local court and they can make an application for bail from the local court. The local court may give them bail, or the local court may refuse them bail, and then they'll be given a next court date. Down the track, once documents have been served, like the brief of evidence, then the person will have to make a decision on whether they plead guilty or not guilty. If they plead not guilty, then they go to trial or local court hearing if the matter stays in the local court. If they plead guilty, then they'll be sentenced at a future date. They can be sentenced in the local court if their charge stays in the local court. Some matters are considered too serious to stay in the local court, so they might have to be sentenced in the district court or the Supreme Court. So that's a very brief overview of what is a very long process in the criminal justice system. So the role of police is to investigate. Police will get some information, and they will look for other information to support allegation or to support perhaps the innocence of the accused. So police are meant to provide documents or evidence, whether it's phone calls, video evidence, or anything, which may also assist the accused person. Police are not meant to withhold information that may actually prove somebody's innocence. They're meant to simply investigate and produce the information. You would think if there's information to prove somebody's innocence that the charges should be withdrawn. It doesn't always happen though. Role of police to investigate, the role of the lawyer and interpreters. Role of the lawyer, you may have a lawyer at the police station. Often there is not, but if there is a lawyer at the police station, the lawyer will sit with the accused while they're being interviewed. And interpreters, you can interpret between the client and their lawyer, or the police questions will be interpreted by you to the accused person, and the accused person's answers will be interpreted by you so that the police can understand what their answer is. And there may also be a support person in place. Some people with an intellectual disability or a mental illness will require police to get a support person for them, and that person may be available in the police station. They may also be present in the interview. So police have special rules and procedures that they're meant to follow for it to be more fair for the person if there is some sort of situation which makes that person more vulnerable. An example, a mental illness or an intellectual disability. Instructions are something that a client gives to their lawyer. They might instruct their lawyer to make an application for bail. They might instruct their lawyer by telling their lawyer their side of the story, what happened, what didn't happen. And a lawyer, a solicitor, may instruct a barrister, which is also a lawyer, to present the case in a certain way at court. So that's what instructions are. The same word can be used in several ways or several examples. Person has a right to silence in New South Wales and across Australia, actually, the states and territories have a right to silence. They do not have to participate in an interview with police, but if they choose to, then that becomes evidence in their case, for good or for bad. It might help them. The interview may help their case, or it may, if they give a bad interview, it may not be very helpful to have done it at all. If there is a lawyer present, then in New South Wales, there is a special caution, an extra caution that is given to the person about anything that they raise in that they fail to raise in their defence now when they're talking to police may not be able to be used later as a defence in court. So if they choose to have a lawyer with them in the police station, they're given an extra warning, an extra caution that anything that they fail to say now to police, which they wish to raise later in their defence, may not be able to be used. ERISP, you may hear this stated especially in trials. ERISP stands for, it's an acronym, it stands for Electronic Record of Interview with Suspected Person. So when somebody's been arrested, they are a suspect. And it does not mean they're guilty, but police suspect that they may have done a crime. So that's what ERISP stands for. It's the Electronic Record of Interview with a Suspected Person. A shortened version of that acronym is ROI, Record of Interview. And that is, record of interview is with the suspect, the suspected person. An inducement. At the end of the police interview, if you're interpreting at the police station, you'll hear the police will come in, a different police officer will come in and ask the person, has any promise been made to you to give this interview today? Has any inducement been made to participate in the interview today? So an inducement is like a promise or an offer, a bribe, so to speak. There should not be any promise by police officers to a person in exchange for them giving an interview. There should be none of that sort of stuff. So the person is asked, has there been any promise, favour or inducement for you to give evidence, for you to give the interview today? They'll be asked that question. It's like an inducement, an enticement. Something is on offer in exchange for giving the interview, and it's not meant to happen. COPS, another acronym, Computerized Operational Policing System, and you have a COPS event number. So every time somebody reports something to police or a charge is created, an investigation is opened, everything's given a number, a reference number, and that's called a COPS event number. We also have H number, and you'll hear this a lot in the local court in particular. You'll hear the magistrate and the lawyers referring to H number. That is a reference number that the police generate, or the police system generates for every single charge. Sorry, not every single charge, but every single arrest where charges are laid. So an H number is, it has H in front of it. No one knows what the H actually stands for, but it's H, and it has a series of numbers. And each arrest, each charging after arrest has a different number, different H number. So some people might be arrested 4 times for different series of charges, and each of those arrest that generates or results in some charges will have a different number. And so sometimes at court you have the magistrate saying, look, I have 3 H numbers here, meaning 3 separate investigations for one person, and they might refer to a couple of those numbers. They might say H number ending in 053. So then the lawyers will look at the paperwork to make sure they're referring to the same piece of paper, the same police fact sheet, because every police fact sheet will have that number in usually the top right-hand corner. Sequence is a charge. So every H number, if there is more than one charge, like armed robbery, assault, occasioning actual bodily harm, and larceny, those might be 3 charges under the 1 H number or reference number, and they might be sequence 1, 2, and 3. So sometimes in the local court, you will hear the lawyers say, my client is pleading not guilty to sequence 1, guilty to sequence 2, and sequence 3 is being withdrawn by the prosecution. So the sequence refers to a particular number charge on that document under the H number, under that reference. Local court, you hear this all the time. Statement of facts or fact sheet or agreed facts. Every time the police lay charges, they type up a document called the fact sheet or police facts. And that is a document which is given to the local court. Does not mean it's agreed to at this point. Doesn't mean that it's everything that's going to be produced in the brief of evidence, but it's the initial document when somebody is charged with an offence. And if somebody's going for a bail application, the fact sheet is what the magistrate will read. And it's a brief summary written by a police officer saying what they summarise the allegations to be. And it's only usually one side of the story, so it does not usually include the accused person's side of the story. I mentioned bail or release applications. So both words mean the same thing. A release application or bail application. We refer to the Bail Act 2013. It's a piece of legislation and it's constantly updated by the politicians, by the Parliament. So though it was made in 2013, there are frequent changes, sometimes yearly, updating it. Bail is, if you're on bail, you are not free, you are not in jail, you are in the community, but you have conditions. And each person may have different set of bail conditions imposed by police or imposed by court. And it might include reporting to police every day, twice a day, once a week, 3 times a week. So reporting to the police station might be one condition. There might be a curfew that you cannot leave home between 10 p.m. and 6 a.m. There might be a curfew. Some people have to deposit or promise to deposit money, or they might need to place a caveat on their house. So the house cannot easily be sold. There'll be there might be $10,000 or $50,000 caveat on the house. So if anybody tries to sell the house, that caveat can cause some issue before the house can be sold. But it's like a promise, that money is like a promise to forfeit that money if the person fails to turn up to court, if the person breaches one of their bail conditions. There may be rules, do not talk to the prosecution witnesses, that sort of thing. So there's any number of bail conditions can be imposed. Bail is decided by the court or initially by police. Police can give people bail, but otherwise, if police refuse, then a person can apply to the court and the court will have to decide, look at what the offence is, how serious it is, look at the person's criminal record, and do they have a history or a pattern of behaviour of failing to attend court in the past? Or do they have a habit of breaking the rules of their bail and committing a new offence while on bail for something else? So if their criminal record suggests that they have a habit of breaking the rules, then it's going to be harder, not impossible, but harder to get bail this time. So criminal record fact sheet is looked at, and what rules can be put in place to ensure that the community or the alleged victim is safe, that the person is not going to run away and fail to appear in court. So you might have to forfeit the passport. There might be a rule, do not go to a domestic or international airport, do not leave the state, do not leave the country. What conditions can be put in place, if any, to ensure that the person turns up to court and does not break any more rules? And certain offences, like offences that carry life imprisonment, maximum penalty like murder, or manufacture of large commercial quantity of drugs, for example, or what's called show cause, which is the third dot point there on the left, show cause offence. There is a list of offences, charges, allegations at this point, which are called show cause, and they are harder to get bail for than if it's not one of those offences. So it's part of the legislation. So when I'm making an application for bail, I literally go back to that piece of legislation, the statute, and the Bail Act, and look at what is my client's charge and does it fit under this section? What am I going to argue for bail for this person? And Section 74 is a rule that if a person has already made an application in, for example, the local court, then they can't bring another application in the local court unless there's something different and new, or unless they were unrepresented the first time. and that new information must materially, or I can't even say the word, or significantly change the situation for them. So maybe there's a medical reason that why they really need bail. Sometimes there's a funeral that they need to attend, a family member funeral, something that's different that was not submitted in the past that makes there a real change in their circumstances. Otherwise, they have to go to Supreme Court bail, and which Supreme Court is higher than the local court or the district court, and they can make the same application that they made in the local court in the higher court and try their luck there. So that's something about bail or release applications.
Helen, I'm just going to jump in here. There's a question about what's the best way to paraphrase or explain show cause? What's another way you'd say that?
It's a test. It's a test which is in the Bail Act, and there are a list of offences under a particular section of the Bail Act which have this extra test that you must satisfy before the court will continue with your application.
Is it generally more serious offences?
More serious, or if the person is already on conditional liberty. So there's certain types of offences that have example, like I said, life imprisonment is one factor that may make an offence what's called a show cause offence. But it may also be that the fact that the person was on bail or parole at the time of this new offence, that therefore it makes it show cause. So they have an extra hurdle, they have an extra problem to get over before the court will even continue to look at how can we ensure that this person, what conditions can ensure that this person will turn up to court, won't reoffend, won't be a threat to community or the victim, that sort of thing. So those things are bail concerns. The court has some concerns or some worries. Every case they need to be satisfied the person is going to show up, is not going to reoffend, is not going to threaten community safety or other people, that sort of thing. So, but you won't get past the show cause hurdle, or it's an extra test that you must satisfy if your charge falls into the particular criteria. And it's a section of the legislation, so it's very specific to New South Wales. Other states will have different bail legislation or different rules for how to get bail. It's just one of those things that I explained, like it's a hurdle, it's an extra hurdle. But you've really got to look at each case is specific. You have to look at your client's criminal record. Were they on parole? Were they on bail at the time? Have they done this offence while on parole or while on bail? Bail is not about guilty or not guilty either. But you have to presume that if the courts, they've been accused of this thing while on parole, then they've got this extra problem of show cause offence, extra hurdle, extra test that they must pass. Yeah.
All right, I'll let you keep going. And while I'm unmuted, I'll just let everyone know that we're going to have 2 short breaks. It's quite a long session today. At around 11 o'clock and 12 o'clock, we'll have 5-minute breaks. So everyone can stretch their legs. All right, thanks, Helen. I'll let you keep going. Did you want me to change slides?
Yes, please.
Okay.
Yeah, thank you. So people at court that you will regularly see are lawyers, which includes barristers and solicitors. Both solicitor and barrister are lawyers. They both have law degrees. They'll have different roles if they're both involved in the same case. So solicitors can still do sentences. Solicitors can also do trials. Solicitors can do local court defended hearings. But solicitors can also engage or instruct, and we had that word before, instruct or instructions. We can instruct a barrister to appear and cross-examine witnesses, for example, at trial in the district court or Supreme Court. Barristers can also appear on sentence. Sometimes solicitor will engage a barrister to appear on sentence, and the barrister will be the one then that does the submissions verbally and in writing. So solicitor will organise the conferences with the client and the barrister. Solicitor would probably speak to the client more than the barrister does. The solicitor is kind of the middle person. The client will ring the solicitor, won't ring the barrister directly normally. In court, visually, in the local court, you can't really tell the difference between solicitor and barrister because both will be in their suits, but the barrister will not have their wig and their black robes on in the local court. In the district court or Supreme Court, the barrister can be distinguished by their clothing because they will have the wig and the black robes on in the higher courts. You'll have the magistrate in the local court, which we call Your Honour. You have judge in the district court, which we call Your Honour. And in the Supreme Court, we call them justice. And we say Your Honour. Registrar will be at all levels of courts, and sometimes they will deal with administrative things like return of subpoena. The associate, there'll be an associate to the judge of the district court or the justice of the Supreme Court, and they assist. They sit just in front of or next to the judge, and they assist the judge with research and administrative tasks, collecting all the exhibits in a trial, that sort of thing, and communicating with the lawyers. Police prosecutor, they are a sergeant of police in the local court. They are not in police uniform, so they'll be in a suit. Male or female, they'll be a sergeant. That's their rank. And they will run defended hearings. If a person is defending the case, they will prosecute in the local court. And they will also appear on sentence. If somebody is pleading guilty, or they're found guilty, the police prosecutor will represent the community or represent the police, in that case in the local court. But again, they're not in police uniform. And Crown prosecutor is a barrister that can be employed by the government for the office of the Director of Public Prosecutions or the Commonwealth Director of Public Prosecutions. They can also be a private barrister in private practice who is employed for a particular case by the prosecution, by the state or Commonwealth DPP. So they can have their own private business, they can do defence work and prosecution work. So private barristers can also prosecute if hired for that particular case. Senior counsel is the same as King's Counsel or KC. It used to be Queen's Counsel when there was the Queen of England. Now that there's King Charles III, it's King's Counsel, and that is they apply to become senior counsel or King's Counsel, and once a year people are appointed, barristers are appointed as King's Counsel or senior counsel. Interpreter, that's yourselves at court, very important person at court is the interpreter, and you might be asked to go and stand next to the microphone. Some accused are on video link at jail, so you might interpret while the accused or the offender is on video, or the person might be in court and you might go into the dock, sit next to the person in the dock, or you might go and interpret at the witness box between the jury and the judge in the district or Supreme Court. Court officer is a person that assists everybody in court, passing documents, technology, making sure that all the microphones are working, etc. And the court officer is the person that interpreters approach to give your ID and also to sign any documents to say that you've come to court to interpret today. So that's the court officer. Sheriff deals with security in court of the courthouse, and they'll be on duty when you enter the courtroom, the security when you enter the courtroom, and they also deal with lots of things behind the scenes like jury duty and things like that, and investigate different things. Jury in district or Supreme Court, 12 random citizens who decide guilty or not guilty in a case. And so New South Wales, yep, we have 12 people on the jury. I don't know why it's 12. It just is 12 in criminal trials. It's just we've borrowed that from the UK. So they're various people that you will see in court.
Thanks, Helen. I'll just jump in again. We've had a question, just to clarify again, is a lawyer and a solicitor the same thing? So the way I explain it is that a lawyer is more the umbrella term. So barristers and solicitors are both lawyers.
Yeah.
But yeah, but also it is confusing because we often use lawyer and solicitor interchangeably. So I might have introduced Helen at the beginning. She's a lawyer at Legal Aid. So we do say that, but it's also accurate to say she's a solicitor at Legal Aid.
And so we all have law degrees. Barristers and solicitors both have law degrees.
And I will just plug here, if you want to go to if you search for Legal Aid New South Wales YouTube, we recorded some webinars during Law Week last month. And one of them was where we spoke to a magistrate, a barrister and a solicitor. So we really explained those types of differences. So if you want to go back and watch those, you can. And we also talk to different solicitors at Legal Aid, so from crime, family and civil divisions, and from LawAccess. So if you're interested in those types of things, feel free to go and watch those free webinars on Legal Aid New South Wales YouTube. Thanks.
So here are some common words used in court for criminal law. Prosecution. It can be the prosecution, like the lawyers for the prosecution or the police prosecutor, or it can be the prosecution of a case, the presenting of the evidence against an accused person or a guilty person, a person that's pled guilty and being sentenced. So the prosecution can be a body or an entity, or it can also be the verb, so I should say the noun. To prosecute, so it's a verb, it's also a noun, and it's also people. Defense is the defense representatives, but it can also be a defense or a version that the accused person gives, their version of events, saying I'm not guilty. So it can be the defense team, the defense lawyer, the defense barrister, the defense solicitor, but it can also be something that the accused person raises to say I'm not guilty of the crime. It might be an alibi defense, might be self-defense, might be I did not do the crime at all defense. So there are different ways in English how that word has multiple meanings in English. The defendant is the person that is defending the charges. They are accused of the charge and they are defending the charge. They've pled not guilty if they are the defendant. Accused, another word for the defendant, an accused person is accused of a crime. They have pled not guilty, and or even before they've pled not guilty, they are the accused. They haven't been found guilty at this point. Co-accused is when there's more than one person that are accused of the same crime or participating in the same crime. They are co-accused. Offender is when a person has pled guilty or they have been found guilty after a trial. And a co-offender is when there's more than one person who has pled guilty to the same crime or been found guilty by the jury of the same crime, co-offender. If something is fixed for mention, it means that the matter has been given a court date, set down, stood over, fixed for mention. A mention is a short court appearance. It's usually administrative. It might be to tell the court what stage the parties are up to. Do we have all the documents yet? Yes or no? What is the next step in the case? It's not, if a matter is listed for mention, it is not going to finish that day. So when you get booked for a court appearance and you see mention on the court list, on the app or wherever you're finding the information, the booking says mention, it won't be finished that day. It could be a 5-minute mention, but it could also be half an hour. So there's different sorts of mentions for different reasons. And it might be a mention to say that the trial is ready to proceed next week. Or it might be a mention to check whether police have served any documents yet. Mention is, it will not complete today though. That's the key thing about a mention. Hearing or a trial. So a hearing can be multiple things in criminal law. It can be a sentence hearing where submissions will be made. Evidence may be called. Lawyers will be doing the talking. Client might give evidence in court. Prosecution witness may give evidence in court for a sentence hearing as well. A victim impact statement, which I'll come back to explain, but that may also be read out at the sentence hearing. The trial will be district court or Supreme Court with a judge and jury, or sometimes judge only, no jury, if the person has chosen to be tried by judge only. So trial is in the higher court, and hearing is can be defended hearing, can be a sentence hearing. So somebody might have pled not guilty in the local court on a charge of shoplifting, and the magistrate will decide guilty or not guilty. The prosecution will be the police prosecutor, and the accused will have a lawyer unless they're representing themselves, and the evidence gets called and the magistrate decides guilty or not guilty. But district court or Supreme Court, you'll have a trial with the jury, and the jury will decide guilty or not guilty. And you'll have your prosecution lawyers and your defense lawyers. Special fixture, this will often happen perhaps in the local court sometimes to sort of guarantee that the time and will be set aside for that matter to start and finish, will be allocated a courtroom and a magistrate, because the local court is so busy and it has so many matters every day that they need to set aside maybe 2 days, 3 days special fixture to guarantee that this can actually start and finish, because if it is in the list with 100 other matters and it needs 3 days to be dealt with, then it just won't happen if it's in the list at random with 100 other matters that day. So the time is specially put aside in the diary for that matter to start and finish. Sometimes you'll hear that special fixture in the district court as well, but normally that's something that's given to local court because their diary is so full of so many matters, keeping in mind everything starts in the local court. Evidence in chief is a witness, can be a civilian, can be a police officer, can be the alleged victim, can be the accused person, can be an expert like a psychiatrist or a doctor. Evidence in chief is the person or the witness answering questions that are asked by either the prosecution if they are called as a witness for the prosecution case, or evidence in chief of the accused who is asked questions by their defence legal representative, or an alibi witness if they're calling an alibi. Their own lawyer, the defence lawyer, will be asking them questions. That's evidence in chief. When the opposition cross-examines you, that's when the opposition lawyer is asking questions of the witness for the other side. So that's cross-examination. So evidence in chief is getting your story out, answering questions, and then cross-examination is the opposition lawyer testing and asking other questions. Voir dire and Basher inquiry are similar things. So we got asked before we started this seminar, somebody asked for us to explain Basher inquiry. So Basher inquiry, Basher is a case, it's the name of a previous case, and it is where maybe there's a new statement that's been served very recently, and the parties did not have a copy of this while at the beginning of the case, while the matter was still in the local court. And the parties there might be an aspect of that statement, or aspect of an expert report where the parties, prosecution and defence, maybe both or maybe one, wants to just test something, ask a few questions in the absence of the jury, just where the judge is just the judge, just to test something or to clarify something. And then so it is evidence, the person is on oath, they must tell the truth, but you don't want that being done in front of the jury. You just want to hear what the answer is to something, to clarify something. There might be various reasons. Sometimes both sides want this to happen, so there's total agreement between prosecution and defence for a voir dire or for a Basher inquiry. Other times there might be legal argument, that maybe this should have happened when the matter was in the local court. If that statement was available, maybe the prosecution may say, well, the defence should have done this earlier, shouldn't have the opportunity to do it now. But very often these things are by agreement. It doesn't take too long. And then the parties may decide, okay, now we know what that answer is. We will ask that in front of the jury, or maybe you'll decide, no, I'm not going to ask that question in front of the jury after hearing what that answer or that clarification is. So voir dire comes from French, really, but it's that cross-examination, or might be evidence in chief and some cross-examination based on something, usually a report or a statement that's fairly new, and in the absence of the jury. So you see the person, you hear the person speak, they answer some questions, and so you have that information, that clarification.
Thanks, Helen. We've had another question, and it's around how should an interpreter address or refer to the prosecutor or senior counsel or King's counsel, or I guess the barrister in the courtroom. So the example is if they want to ask the judge to ask that person to repeat something. And I just wanted to point out that one of the handouts you should have got was called Tips for Interpreting in Court. And we've got some like little scripts in there. So for example, one of them says, if you haven't understood what someone has said, you can say, "Excuse me, Your Honour." So you're talking to the magistrate or the judge. "Excuse me, Your Honour, I'm speaking as the interpreter. Can you please ask," and it says, "insert name of person," to repeat themselves or use different words. So I guess this question is asking that insert name of person. What do they say there?
So if it's the prosecutor, you'll notice that in court, the prosecutor is always referred to as either Mr. Crown if it's a man, or Madam Crown if it's a woman. So the Crown prosecutor, the Crown the Crown comes from coming from England, the Crown. Okay, so the jury don't hear the prosecutor's surname. They just hear Mr. Crown or Madam Crown. You can also say, you can use defence counsel. You could say could defence counsel please repeat that? Or, Your Honour, may I ask defence counsel to repeat the question?
Counsel is just
yeah.
another word for barrister.
Yeah, or you can say defence counsel, defence barrister. You can say that. In court, the defence barrister will be referred to by their actual surname. So, you know, but you can say defence barrister, defence counsel.
Okay, thanks. Hopefully that answers that question, and have a look at that tip sheet as well. I think that would be useful. Thanks. So Helen, maybe we will I'm just having a look. I think we'll just go through this last slide of sort of general words used in court, and then we'll have a 5-minute break.
No problem.
So we'll just do this slide. Thanks.
So committal hearing is something which may occur, and it doesn't happen all that often. Committal hearing is in the local court, and that might be, that's where an application is made by defence or prosecution, and it might be by agreement as well, to cross-examine a number of witnesses or one witness on very specific part of their statement or their expected evidence. There might be a gun expert, a ballistics expert, that both parties might benefit from clarifying some things or hearing from their expert report that you've both received, and or it might be about an identification issue in the case. So you might call a couple of the witnesses who says they saw or heard something. So you've already received these people's statements from police, and there might be some issue that you want clarified, but you have to be very specific. You have to write an application and be very, very specific what areas you're asking for this particular procedure. It does not happen a lot. It used to happen more, but the law changed in 2018 so that magistrates cannot, in New South Wales, I think other states are different. I think Queensland is different. Magistrates in New South Wales can no longer discontinue or stop the proceedings after a committal hearing. So magistrates have lost that power in New South Wales. So even if you have this hearing, you used to sometimes make one of these applications to test some evidence, and if the result was that the evidence was actually quite weak, then you might then make the application to the magistrate to dismiss the charges now, so that the person does not go to the district or Supreme Court and face trial. Now, New South Wales, the magistrate does not have the power to dismiss those charges while it's in the local court. So even if you have the committal hearing and it's very successful for you, clarifying certain aspects of evidence, it cannot result in New South Wales of having those charges dismissed by the magistrate. So, but the committal hearing may still prove strategically important to clarify some things, to test the strength of some things. So it's really a strategy, which may or may not go in your favour. So you really have to think about strategy and what you want to achieve by doing that. But that's what a committal hearing is. Call over can be, often it's the district court or the Supreme Court. It's a mention, really. It's a short appearance to check, are you ready to proceed for trial, for example. And in Sydney District Court, every Thursday before the trial starts on Monday, we have to go to call over, and the court will just check, are you ready to start on Monday? Or are you ready to select the jury on Monday? those sorts of things. Are there any pre-trial legal arguments that need to be had before you choose the jury? So the court wants to check, are the lawyers ready? What are the problems in the case? What is the delay? Can we have the jury ready for Monday, or is there going to be a delay and we can't have the trial starting until Wednesday? Something like that is all to assist with which judge may be allocated the case, how long is the trial going to take, have the parties narrowed down the issues in dispute so that maybe the trial can be shorter. So that's what a call over is about, but a short court appearance. Interim hearing or an order. This comes up a lot in apprehended violence orders. There might be interim orders which are in the meantime or temporary until we get to the final date, until we get to the final hearing. So it's the case is on foot. We don't yet have we're not at the final trial or the final hearing yet. In the meantime, there might be some orders in place to control somebody's behaviour or to restrict somebody's behaviour, like AVO restrictions, things like that. Yeah. So it's in the meantime or interim between two court dates. Adjournment is an application by prosecution or defence or both to delay the matter or postpone the matter until another court date. So every time there's a mention, there will be an adjournment as well, because the matter will have to be given a next court date. The matter might be adjourned for sentence. So a person might plead guilty and then the matter is adjourned for 6 weeks for sentence to give the parties time to gather all their evidence, to prepare reports, to prepare submissions for sentence. So there'll be an adjournment. It's a delay or it's a postponement. Stay of proceedings can be temporary or permanent. There might be a couple of reasons why a matter may be stayed or an application may be made for a stay of proceedings. It's a stop of proceedings. It does not mean not guilty, and it does not mean withdrawal of charges. It just means the proceedings against a person are stopped temporarily or permanently. It might be because somebody has run out of money and they're not eligible for legal aid either for some reason, but they need time to earn more money or to sell their house to get more money to pay for their legal fees, and maybe they need 6 months to do this. So maybe the case is put on hold, temporarily paused until the future when they might be able to afford their legal fees. Or it might be stayed because of extreme ill health of a person, for example, and the prosecution may not be willing to withdraw the charges because of the health, but the health needs to be really such, maybe it's a terminal illness, or maybe not terminal but extremely frail, and there might also be dementia, something like that, a deteriorating illness. So there might be a stay of proceedings for those reasons, but it's not always easy to achieve that outcome. But it's a pause, if you like. Proceeds of crime. This is often an application made by Crime Commission, police, prosecution lawyers to forfeit, to seize assets that they say are the result or proceeds of criminal activity. So, for example, if there's a lot of money found in a house and somebody is also charged with drug supply or drug manufacture offences, then the money might be considered result or proceeds of criminal activity. And there'll be an application to confiscate that money, or for the person to have to give up that money, forfeit that money. It might be a house that is the proceeds of crime. It might be a car that's the proceeds of crime. So Police, Crime Commission, various prosecuting authorities might seize property or cash and make an application that the person forfeit that money. So forfeiture application, confiscation order, these are all related to proceeds of crime proceedings. Alibi is something where somebody says, I did not commit the crime because I was not even at that place at that time, could not have been me, and you must give notice of this. So you provide a document saying, I was on holidays overseas at the time. Here is my flight itinerary. Here's my holiday photos. Here's proof that I did not commit the crime. I was not in Australia at that time. It may not be as obvious as that. The alibi might be something else. It might be that I was at a shopping centre at that time. I was with my friend at the time. Here's my friend's name. Here's my friend's address. You can go and talk to that person. They can agree that I was with them at the time of the alleged offence. I could not and did not commit that crime. So that's an alibi. But you have to give notice because the prosecution will want to investigate it, and they'll go and get statements or try and prove or disprove that alibi. If the alibi is able to be established successfully, then it should result in a not guilty verdict, or the prosecution should withdraw the charge. So forfeiture and confiscation I've touched on. Jurisdiction can be, has a couple of meanings in English. It can be the location, so New South Wales, Queensland, Western Australia, Victoria, different state jurisdictions. So if a crime is committed in New South Wales, it should be prosecuted in New South Wales. If it's a Commonwealth crime, like importing drugs, usually it will be prosecuted in the state that the drugs were imported into. But when we had a series of what's called generically people smuggling matters, even though the boats arrived on Christmas Island or were intercepted in the ocean, New South Wales, Victoria, Queensland, we still had prosecutions of those people in our states, prosecuted by the Commonwealth. And even though those people never landed or the boat never arrived in our states, but the Commonwealth decided to prosecute matters in various states across Australia. So they weren't all dealt with on Christmas Island or in Western Australia or on the in the Northern Territory. They'll spread around Australia under Commonwealth jurisdiction, Commonwealth law. Jurisdictional error. So jurisdiction can also be whether it's local court jurisdiction, district court jurisdiction, Supreme Court jurisdiction, the power of the court, which is the correct court to prosecute or to deal this matter in. So if there's a jurisdictional error, it might be that something went to the district court when really it should have been dealt with in the local court, or something should not have gone to the Supreme Court, it should have been dealt with in district court. So if there's an error with the jurisdiction, it means it's gone to the wrong court, the wrong level. Judicial error is an error made by a judge or a magistrate. It's a mistake made by a judge or magistrate, and that can be appealed if there's been a mistake in law, or sometimes a factual error, but usually it has to be a legal error, mistake made by the judge or the magistrate. An appeal can be against the severity of a sentence, the length of the sentence, the type of the sentence. So some people might think that 500 hours of community service is too severe, and they might argue that it should be less, or a prison sentence is too severe, and they might argue that it should be less time. The prosecution can also argue that the sentence was not severe enough, or the sentence was inadequate. So the prosecution can also appeal against the inadequacy or the leniency of a sentence. And an appeal can also be against conviction. So if somebody is found guilty by the magistrate or found guilty by the jury or a judge alone in a trial, they can appeal against that conviction. They can appeal to the higher court against that conviction and try to have that conviction cancelled or overturned, and they might get a new trial, or they might have not guilty substituted as the result. So there's some words that you might hear in the local or district or Supreme Courts.
Thanks, Helen. A couple of questions before we go on our first break. One is around, this is a term we use in English that might not be so obvious. So to explain, what does on foot mean?
Proceedings are current. So they're ongoing, they're on foot, they're continuing.
Thank you. And the other question, I guess, is just more for all of our interest. If proceeds of crime or profits are seized or assets are seized, where do they go?
I think the state government, or if it's the Commonwealth that's seizing them, the Commonwealth government. So if it's a house, then they would sell the house and get the money, or jewellery. And I have seen, there are auctions for this sort of stuff as well, when you see like auctions when things have been seized and forfeited, jewellery, all sorts of things can be auctioned off, and people can actually buy these proceeds of crimes, but the money will go to the government.
Excellent. All right. And one final comment before our break. I think a couple of people still have their hands raised. If you do have a question, please just type it into the Q&A. We can see that. I don't think everyone can see the Q&A, but we can still read, and we'll read out the questions. So that's probably the best way to ask questions today. So if you've got your hand raised and you still have a question, please just type it into the Q&A, and you can do that anonymously if you prefer. Thank you. So what we're going to do now is have a 5-minute break. The time I can see now is 11:18. So we're going to start again at 11:23. So please grab a quick cup of tea or coffee, and we'll see you back in 5 minutes. Thanks, everyone. Hi, Helen. 5 minutes goes very quickly.
Sorry.
But hopefully everyone's had a bit of a chance to stretch their legs and grab a quick drink. I guess we'll just start again now. It has been 5 minutes.
Yep.
So yeah, now we're talking a bit about some general words used in criminal law. So I think I've changed the slide already. So
Yep.
Thanks, Helen.
No problem. So summary offence is, they're less serious criminal matters which will result, will finalise in the local court. These charges will not go up to the district court or the Supreme Court. So you'd expect that the penalty will be much less than other charges, or matter can be dealt with summarily, meaning it might be a charge which could, if chosen by the prosecution, go to the higher court, the district court, for example, but the prosecution have chosen not to take it to the higher court and leave it, finalise it in the local court. And the maximum penalty for local court is 2 years imprisonment per offence, with a magistrate is limited to a 5-year maximum accumulation. However, not every charge has a 2-year maximum penalty for it. as its maximum penalty. So, for example, something that's goods in custody, which may be an item which somebody suspected was stolen and has that item in their possession, that's only a 6-month maximum penalty or fine. So that would be the limit. Some offences have fine only, like trespass is a fine only. You can't go to jail for it. So you still have to look at what is the actual maximum penalty for the offence, but summary offence will resolve in the local court. Indictable is something that is a charge of 2 years maximum penalty or more that can stay in the local court, or it can be transferred to the district court, for example, or obviously a murder charge is also an indictable matter, but that goes to Supreme Court and the maximum penalty is life imprisonment. Indictment is, you'll see this in the district court or the Supreme Court if you are interpreting at a trial, or what's called an arraignment, which is also a word on the list. An indictment is a piece of paper which the prosecution present to the court, and it is a document which has the charge or charges listed on it. And the judge's associate or the judge themselves will read out the charges to the accused person, and that person will enter their plea of guilty or not guilty when the charge is read out to them. So that's the document called the indictment, and that happens, that reading out of charges happens at arraignment. And if you appear at Sydney District Court as an interpreter, that will be every Friday in Court 3.1, but different district courts will have a special day, their own special day. It might be a Friday, it might be a Thursday, or it might be a Tuesday. Each district court will have a specific day for this process to occur. And so if the person pleads not guilty, then they get given a trial date. If the person pleads guilty, then they get a sentence date. And so as interpreter, you will be interpreting as the judge reads out the charges. You will interpret what the judge says, and then the person says guilty or not guilty. You'll also do that process in front of the jury. So the charges on indictment are read out in front of the jury, and as interpreter, you would interpret that process of the charge being read out and the accused person saying not guilty in front of the jury, and then the trial begins. Acquit or not guilty. So if a person is found not guilty, then they are acquitted of the charge. It does not mean innocent, though. So not guilty is not the same as innocent. In the trial, in the criminal law process in New South Wales, in Australia, actually, Australia-wide, the prosecution must prove the charge, the ingredients of the charge beyond a reasonable doubt. And if they're found not to have done that in the eyes of the jury or the judge, if there's no jury, or the magistrate, if it's local court, then the person must be found not guilty because the prosecution have not proved the charge beyond a reasonable doubt. There's some doubt about the guilt for whatever reason. So it's not about finding the person innocent, it's finding them not guilty. Penalty is a punishment. It could be a fine, or it could be a conviction with no other penalty. It could be a good behaviour bond, and we'll get different types of sentences later in the seminar. There could also be full-time jail. So penalty is a sentence, but it's a big range of penalties, from involving money to involving jail time. Custody has a couple of meanings in criminal law. You can be in the custody of police after arrest. you're not free to leave. You can be in the custody of corrective services when you're brought to and from the jail to the courthouse. And you can be in custody at the jail in general, waiting for your trial to come to court and start. So they're the words, that's what custody means in a criminal law context. Verdict is the decision of the jury, if it's a jury trial, or the magistrate, if it's a local court hearing, or the judge alone if there's no jury in the district or Supreme Court. Verdict can be guilty or not guilty, or it can also be a special verdict of act proven but not criminally responsible because of a mental health impairment or a cognitive impairment. Sentence is the penalty or the punishment. A sentence is what punishment or what penalty is given to a person who either pleads guilty or is found guilty by the court, by the jury, by the magistrate, or by the judge. So that's the sentence. Every prison sentence has a non-parole period and a parole period. Well, I should say not every sentence. Some are what called fixed term, means that's a set amount of time and there may not be a minimum and a maximum. It's just a set time. That's a fixed term sentence. But most sentences will have the parole period and non-parole period, and the non-parole period is the minimum time that the person must spend in jail, serving their sentence in jail, until they are released on parole. And parole is where they are supervised in the community, still serving that jail sentence, but it's in the community under supervision by a parole officer or community corrections officer. And they'll be sent to do courses, they'll be drug tested, they must be of good behaviour. There's all different conditions in place. A head sentence is the total term. So it's the non-parole period plus the parole period is the head sentence. It's that maximum sentence. Black direction is something that you may hear in a trial where the jury have written a note to the judge saying, we're stuck, we're divided, we can't reach a unanimous verdict, meaning not all 12 of us can agree. So the judge will give what's called a black direction, and black is not the colour black, but it's a case, somebody's surname was black, and this is the wording from that particular case, which is now used and adopted in every other case if the situation arises where the jury tell the judge, we're having trouble reaching unanimous decision. Everybody cannot agree. And the judge will sort of tell the people that you must try harder. I want you to continue listening to everybody, listen to all the evidence, listen to each other's opinions, and try to reach a unanimous verdict where all 12 of you are agreeing. If after 8 hours, the jury write a note and say, look, we're stuck, we can't decide, then the judge might say, well, it's now time. In New South Wales, it's 8 hours. That does not include overnight because jury is not kept overnight and they're not kept on weekends. It is 8 hours at the court in the jury room and excluding lunch breaks because they're allowed to have the lunch break and the morning tea break. So 8 other hours, excluding those times. The judge might say, well, now I can accept a majority verdict, and it has to be 11 to 1. So 12 people on the jury, it must be 11 to 1. And it might be 11 saying guilty and 1 person saying not guilty. If that's the case, then it would be verdict of guilty, majority verdict of guilty. If it's 11 people saying not guilty and 1 person saying guilty, then that could be a majority verdict of not guilty. 11 to 1. It is not 8 to 4 or 7 to 5, or 10 to 2, it must be 11 to 1 in New South Wales. Hung jury is when, despite all of that, the jury are still so divided that they cannot make a decision. They cannot make a unanimous decision. Some people say guilty and other people say not guilty. And if they write a note and say, we are stuck and we're not going to be able to come to a unanimous decision no matter how much longer we discuss this, then it's a hung jury. No verdict is reached, and they will be basically discharged or sent home. Trial will finish and has to start again, maybe immediately or maybe in 6 months' time, 12 months' time. The person has to start again with a new jury and possibly a new judge.
Thanks, Helen. Before we move on, there's one question about this, a lot of words. Can you please explain what does summarily dismiss mean? Is that something you hear?
Summarily is something's dealt with in the local court. And if something's dismissed, then it is the charge is got rid of, it's ended, it's dismissed. It might be like withdrawn and dismissed as well, or summarily dealt with. It's dealt with in the local court, not going up to the higher court. But if something's dismissed, magistrate can dismiss a charge, and that means that the proceedings will stop. There'll be no conviction for that. The charge is dismissed.
Thank you.
Okay, so to charge somebody, to charge is the verb, but a charge can also be a noun in English. And somebody is charged by police, or police lay charges against somebody. So charge is both a verb and a noun in English. And obviously every language is different, so I'm not sure whether there are differences in your languages between the verb to charge and a noun of a charge, or when somebody's charged by police and police lay charges. In English, the word has verb and noun meaning. Form 1 offences, these are, it's a crime, it's an offence where somebody has admitted that they're guilty of that crime, whatever that crime is, and they're asking the court, can be local court or district court or Supreme Court, to take that offence that they say they're guilty of, that they admit they're guilty of, take it into account or consideration when they're being sentenced for something else. An example of this might be a break and enter crime. Person has pled guilty to breaking into a home, and while they broke into the home, they stole the handbag of a person, and then they used the credit cards of that person at 3 different shops. So they might also be charged with the fraud, or the obtain benefit by deception, using that credit card, pretending to be the owner of the credit card to shop and make purchases on that credit card. They might say, I'm guilty of doing that, but ask those fraud offences or obtain benefit by deception be placed on this document called a Form 1, and it's a part of a Form 1 it's part of a legislation, part of one of the pieces of legislation. The document will have all these words on it, and the consequence of that is that they will not be given a separate jail sentence or a separate good behaviour bond for that charge that's placed on a Form 1, but it will be known to the court that they've admitted that, and that they've admitted their guilt to that, and the judge will know that they've done these other crimes in addition to the charge that they're pleading guilty to. But the benefit to the accused, or the benefit to the offender, is that they won't actually be given an additional sentence for that charge that they're admitting their guilt to. That's a Form 1 offence, and there'll be a document that they have to sign. So you may need to interpret or translate on site that document, or do that in a conference with somebody as the lawyer is explaining what that document is that they're asking their client to sign. Backup charge is something that is a less serious offence. So it's a backup. It's an alternative charge that, for example, dangerous driving might have a backup charge of negligent driving, or supply prohibited drug may have a backup charge of possess prohibited drug. So usually you will not plead guilty, or you won't usually plead guilty or be found guilty for both. You might choose to plead guilty to the less serious charge and ask the prosecution to withdraw the more serious charge. Or at trial, you might plead not guilty to the more serious charge, like you might plead not guilty to dangerous driving causing death, but the jury, or you might offer to plead guilty to negligent driving causing death. And if that's the result, if that might be accepted by the prosecution, or that might be accepted by the jury, then you'd be sentenced for the less serious charge, which will have a less serious maximum penalty. Usually...
Sorry, Helen, to interrupt. I might just jump in there because there was a question earlier, and this might be a good time to ask it around that specific charge you just mentioned.
Yep, so I've answered that. Yep, so negligent driving, I did answer that in the Q&A.
Okay.
Typed an answer. So negligent driving, it might be an example of looking at your phone while you're driving, not completely paying attention, or some sort of distraction. You might be negligent because of that, but dangerous driving will usually have something more criminal involved, like taking drugs and driving, high speed, and especially if it's raining and dangerous weather conditions. But another crime like speeding, illegal drugs, alcohol, that sort of thing, that would be considered dangerous driving, whereas negligent might be not taking care not to be distracted, that sort of thing.
Thank you.
Some
That's
example.
clear. Thank you.
So yeah, so a backup charge will be less serious than the more serious charge. Sentence assessment report. This is a document which is a report which is written by corrective services, or an officer called a community corrections officer, parole officer. They supervise people in the community after they come out of jail, or when they're on an intensive correction order, which is a type of sentence which I'll get to later. These reports will have an assessment of suitability for community service, yes or no, suitability perhaps for home detention, yes or no, and they'll also talk to the person about their attitude towards the offence. So these reports go straight to the court, and they can be dangerous for an accused person if the accused person has said some things to the report writer, which the report writer considers to be, example, bad attitude, blaming other people, not taking responsibility. The report goes straight to the court, and if it's bad, then it can also affect the sentence. The sentence may end up being more severe than if it was a good report. Agreed facts are where the prosecution and the defence agree on the summary of what happened. Agreed facts, the fact sheet is a summary of what occurred. Somebody has pled guilty, and there's a statement or a summary of what happened, what the person did, and this is a document. It's much shorter than the whole brief of evidence. An agreed facts document saves the court a lot of reading time. So instead of reading 7 lever arch folders of material and watching all the CCTV footage. Agreed facts might be 3 or 4 pages. Agreed facts can also be used in a trial where there is no dispute over certain things. Might be a relationship between 2 people, where people were living at the time. There's no dispute, so that it's agreed, and therefore the prosecution don't need to prove person was living at this address. It just saves a lot of time with calling witnesses on every single piece of evidence. So it's a very sensible way of dealing with things. It does not have to be argument on every piece of evidence. Attempted is where somebody tries to commit a crime, but for some reason either fails in their attempt or it doesn't succeed, it doesn't work. So an example of that is an attempted armed robbery. Person goes into the shop with the intention of committing an armed robbery. They have the weapon, etc., but they actually don't achieve that result because they actually don't achieve getting any property. Maybe they get scared off by an alarm and they run out of the shop without actually taking any property, but they certainly attempted to rob the place. Or maybe the victim in the shop fights back and doesn't give up any property, so the attempt of robbery fails to achieve receiving any property, but the person still attempted to do that, and the penalty will be the same. An attempted robbery has the same actual penalty as a successful, so to speak, robbery. So that's what an attempted charge is, an attempted crime. It's certainly tried to do it, but for whatever reason failed to do it. Actus reus and mens rea, these are Latin terms, and a lot of English has, and law has Latin words in it. Actus reus is the actions or the physical acts of a crime that the prosecution must prove. Mens rea is the mental element that the prosecution must prove. So let's take the example of murder. Murder is where somebody has been killed, that there is a death, and there is an intention to kill or to cause really serious injury. So the mens rea, the mental element, is the intention to cause really serious injury or to kill. That's the mental element or the mens rea that the prosecution must prove. The actus reus is the act that caused the death. It might be a punch, might be a stab wound, might be a gunshot. That's the actus reus. So 2 Latin words there. Burden of proof, you'll hear this in criminal law all the time, and civil law as well, but we'll concentrate on criminal law. Burden of proof, in a criminal case, the burden of proof or the onus of proof is on the prosecution to prove the ingredients or the elements of the offence beyond a reasonable doubt. So the prosecution has the burden of proof. It becomes balance of probabilities when the accused is raising a defence of, example, mental health impairment or cognitive impairment defence. That is when the defence has the onus or the burden of proving their defence on the balance of probabilities. So more probable than not, it's not quite as extreme or hard or high a hurdle as beyond reasonable doubt. But if it's any other crime, then where you're not raising a defence of mental impairment, then the prosecution must prove the elements or the ingredients of the charge beyond a reasonable doubt. And the jury will be told what those ingredients or elements of that particular charge are, that the judge will explain that to them. And so that's the burden of proof. And if there is considered reasonable doubt, then the jury will be told you must find the person not guilty. But if there is no reasonable doubt, no other rational explanation, then they'll be told that they can return verdicts of guilty. Objective seriousness, this will be a phrase that you'll hear in sentencing. And the judge or the magistrate must consider what is the objective seriousness of this crime, of this particular example of the crime. So when a judge talks about objective seriousness, or the lawyers talk about objective seriousness, they're really comparing this robbery with other robberies that the court may have sentenced people for, or comparing the facts of this robbery with the facts of other robberies when you research case law and examples of other cases, comparing and contrasting the factors or the facts in the case. Every case is different, so there might be some fact which you can't find a similar example of elsewhere, but others are very common offences, and so they might have some factors that are common in all of them. Now, let's look at the robbery example. Let's look at an armed robbery example of objective seriousness. It would be more serious if the person has planned it they've got the balaclava, the disguise, they've got gloves, they've broken the CCTV camera because this is very planned. They've been watching the shop for a week and they've decided this is the place I'm going to rob. So they've looked at the cameras, they've worked out the best time to do it. And it's the end of the day, the poor person's counting the money in the shop. So the robber has decided, I'm going to rob this place at 5 p.m. when the person's by themselves. And maybe there's a lot of violence involved, use of the weapon. There might be really bad verbal threats, scary stuff said, and there might be a lot of money taken. And that's part of the plan because they've timed it when all the money is there at the end of the day. Less serious than that would be where there's a threat of violence. There is a weapon, there's some sort of threat, but there's no actual violence. No one is actually injured, physically injured. Certainly psychologically, yes, it's scary. Maybe there's less property stolen, and maybe they haven't destroyed the shop, they haven't damaged property in the process of the robbery, they haven't smashed any windows, and maybe it's not so planned. There's no disguise, they can be easily seen on the CCTV, easily identified. Everyone can see their face, so it's not well planned and disguised. That would be less serious at law than the one that's very planned, a lot of violence, a lot of money stolen. That's just an example of what objective seriousness is about. It's not comparing murder to robbery. It's not comparing shoplifting to robbery. It's comparing robbery to robbery, murder to murder. Special circumstances is the personal circumstances of the offender, of the person being sentenced. Special circumstances might involve many different things or one thing. It might be that the person is very young, very sick, very old, mental health issues, cognitive impairment, first time in jail, no family in the state or in the country, no support. Those sorts of factors can result in a finding of special circumstances, and that will affect the structure of the sentence, of a prison sentence. So if the judge or the magistrate finds that there are special circumstances for one or many reasons, then the magistrate can reduce the time in jail and increase the time on parole. So I discussed earlier that a prison sentence has two parts, non-parole period and parole period. A finding of special circumstances, which is personal to that particular person, can result in a restructure of the sentence, reducing the minimum time that they must do in jail and increasing the time on parole under supervision. Precedent, I mentioned a precedent before. Common law creates, judges create precedents, or judges follow precedents, or magistrates they follow other cases. Cases become examples. So a precedent is an example. It sets an example for other courts to follow.
Helen, we have a few questions. There's also victim impact statement on this slide. Is that something to talk about now? That's all right.
I can't see that. Okay, yeah, victim impact statement is a document or a letter or a statement written by either the victim of the crime themselves or the family of a victim. So in a murder matter, the family of a victim, partner of a victim, child of the victim may write a letter to the court. The victim can choose to read the letter out themselves or have a support person read the letter out to the courts, how they feel about what happened, about the crime, the impact of the crime on that person. Or sometimes the letter is given and it's not read out loud in court, but the judge reads it and acknowledges the suffering that the victim has gone through as a result of the crime, or the family has gone through as a result of the crime. And it's the person's feelings. Then the victim impact statement is not meant to call for a particular type of punishment. That is not the role or the purpose of a victim impact statement, but it is very much allowing that person to say to the offender and to the court how this has affected my life, how this has affected me.
Thanks, Helen. So a few questions from this slide to clarify. Is there such a thing as, so charges in New South Wales, can they be a statutory offence or a common law offence? Is that a...
Yes, so a statutory offence is statute, is a piece of legislation. Like, for example, anything in the Crimes Act is any section of the Crimes Act, 1900, New South Wales, that's a statute, and a charge under that is a statutory offence. I'm trying to think of a common law offence. I'll have to come back to think of common law offence, because people are always charged under a statute. You may hear statutory alternative. So somebody might be charged with murder, but manslaughter is a statutory alternative. Manslaughter can be a charge in its own right. It's like an unlawful killing, but it lacks the intention to kill or to cause grievous bodily harm that murder has. So the mental element of murder and manslaughter is different. Manslaughter lacks that intention, but
so
it
we'll
can be a
get back
statutory alternative.
About the common law offence. And the next two questions really flow on from what you just explained. So just to clarify, attempted murder has the same penalty in the Crimes Act as murder?
Okay, that will be the one exception there, because there'll be different types of there are different things can result in attempted murder, and in the Crimes Act, there are different types of attempted murder. So that would be the one. I'm just going to have a look at the Crimes Act, because there's new each year. There's something new that's brought up. So there are different types of killing, and there's there's also an act causing death, which is, again, it's not murder, but there is Section 27 of the Crimes Act, acts done to a person with intent to murder is 25-year maximum. So Section 27 is administering poison or some sort of destructive thing which wounds or causes grievous bodily harm to the person with the intention to kill them. That is to commit murder. That is 25-year maximum. Acts done with property, like setting fire or explosives to property with intent to murder, is 25-year maximum. And other sorts of attempts to murder, again, attempts to administer poison or other destructive things, shooting, attempting to drown, suffocate or strangle with intent to murder is 25-year maximum.
I think for our purpose today, yeah, thanks, Helen. And if people are interested, they can look up, you can search up for the Crimes Act New South Wales and have a look for yourself if you'd like to look at the legislation. Anyone can do that.
But other attempts are the actual maximum. So yes. Murder has life, and 25 years is, but for attempt murder, it's 25 years maximum. But other things, it's the same. The maximum is the same as whether you attempt to do it or actually succeed in doing it, because the intention's what's the important thing there.
Thanks, Helen. And just to clarify, coming back to mens rea, would you describe that as the thought to commit a crime, or is it also a plan? No, can you maybe
it's the intention. So, I mean, I think, in England, people used to be convicted of, tried and convicted of thinking thought crimes, but that not the case, like treason and things like that, or people used to be prosecuted in the past of thought crimes. It'd be very problematic because I'm sure many people have thoughts of committing crimes, but no, it has to be, it's an intention, it's the mental element, it's the intention. It can also be a recklessness, can be the mens rea. It's the culpability or the degree of thought that goes in, not thought as in I want to rob the shop. I'm thinking of robbing the shop, but I don't actually go and do it. I can't be charged with robbery for thinking about robbing the shop. It's the intention to go in there and permanently take away somebody's property by threat or by force is that intention to do that is the mens rea of that. The intention to kill or cause grievous bodily harm is the mental element in murder.
Thank you.
And some kinds of reckless wounding or intentional wounding. That's the mental element.
Thanks, Helen. I've just moved on as well. So we've got, time is going quickly. We've got one more hour of this session. We will have another break soon before we start talking about more specific offences. So maybe after this next few slides, we'll have another break. Somebody has asked about sentencing, but I think we'll leave that because we are going to talk about sentencing later. So we might just move on, Helen. And there will be, this webinar is being recorded and it will be on YouTube if people want to re-watch anything. So we'll move on to the next slide about more legal document words. Thanks, Helen.
So court attendance notice, or CAN as the acronym, that's a document that police produce when a person is charged. It has the charge written on it. That's the court attendance notice, and it will have a date that the person must attend court. Affidavit is a document which is a sworn or affirmed written evidence. Many people, including lawyers, many people make affidavits for court, and including lawyers make affidavits for court, and it's it's evidence, it's written evidence, and it must be true and correct. It must be the truth, because you are swearing or on oath or affirmation that it's the truth, and you can be prosecuted if you write anything in there that is not the truth. So the deponent of an affidavit is the person who is making that affidavit. Statutory declaration is also a written document which you are declaring or you're saying is the truth. And statutory declarations are used in many aspects of everyday life as well. When we travel and we come back into Australia and we have to sign the customs document, and there's a little statutory declaration that what you're saying is true and correct about what you are or are not bringing back into the country. No food, no wood products, etc. So that is a statutory declaration. Passport applications have a statutory declaration, many things, and they're witnessed. Both of these are witnessed by Justice of the Peace or a solicitor, or except for the statutory declaration doesn't have to be witnessed when you're coming back into the country. That one doesn't, but some statutory declarations you get it witnessed by a justice of the peace or a solicitor. So they do become evidence, and you can get prosecuted for false statements. Notice of motion. So in court, if I'm applying for an order of the court, I do a document called a notice of motion, and I have to justify it or support my argument for that order with an affidavit in support, setting out the reasons why I'm asking for the court to make a particular order. An example of this is my client might be going to trial with a co-accused, and we use that word, so somebody else going to trial with us, and I might want my client to be separated from the other person. So I might write a notice of motion seeking an order that my client be given a separate trial from the co-accused. That's the order that I'm seeking, separate trial. But I also have to put in my affidavit the reasons why I'm asking for a separate trial. So that's affidavit and notice of motion. They go together in court, but you can also have affidavits separately. Sometimes I'll get a client to prepare an affidavit for their sentence matter as well, setting out their personal life story, and that can become evidence of their life story, and the prosecution can still cross-examine them on that, but it may also save some time. It becomes evidence. It may save time repeating all of that in court. It's already written down, and maybe the prosecution will not ask them any questions about it anyway. Subpoena is a document which prosecution or defence files at the court registry. The registry stamps it, and it's an order to produce documents or to appear to give evidence at court. As an interpreter, you may be given a subpoena to attend court, as if you have been the person that has interpreted listened to and interpreted and translated phone conversations which have been intercepted, or you've been the interpreter at the police station in the ERISP, you might be subpoenaed to attend court to give evidence. Prosecution witnesses are subpoenaed, defence witnesses can be subpoenaed. It's an order to attend court. If you don't attend court, there's a warning on the document that a warrant may be issued for your arrest. And I will often issue a subpoena. It might be on the police, it might be on the hospital, to produce documents. So I might want a particular document or a particular piece of evidence, like telephone calls, produced to the court, and then those have to be produced, and then I can seek access to those documents which are produced. Oath or affirmation, you as an interpreter give an oath or an affirmation before you start interpreting in court. Jurors give an oath or affirmation before they start listening to the evidence. And oath or affirmation is also on the written document as well. Warrant, I mentioned, there'll be a warrant issued by the court or by police to arrest somebody. If they fail to appear in court, if they fail to produce documents when required, that there can be a warrant issued for arrest. Without prejudice is something, or without admissions, something that I will write on my correspondence if I'm making submissions or representations to the prosecution. I might be asking them to please withdraw a charge, and I might be suggesting that a more appropriate charge or a different charge or a backup charge or a less serious charge is the more appropriate charge when I've read all the evidence, and my client would be willing to plead guilty to something different. If they were to offer that, can they please consider this submission? And, so just in case, so it doesn't get used against my client, if it's rejected, the prosecution can't use that against my client. If they reject the submission, if they reject the offer, and they proceed with the more serious charge, they can't use it against my client that I did offer to make a plea of guilty to something less serious. The jury, for example, would not learn about that if it's going to go to trial on the more serious charge.
And without admissions?
Yeah, so I'm not, even though I'm saying we might offer to plead guilty to something, I'm doing this, they can't use that document. I'm not saying we're definitely guilty, we admit our guilt to this. I'm just sort of proposing that perhaps the evidence supports a finding of guilt, or it suggests some different offence may have been committed, but my client's not admitting it at this point. If you accept that offer, different story. My client would plead guilty and would admit it in court later. Right now, though, I'm not actually locking that person in to admitting it, but I would like you to consider this without using it against them.
Yep. And there's a couple of more questions about these words. An affidavit and a stat dec. So let me just try and summarize that. An affidavit is generally the document that's used in court as evidence.
Yes.
And a
yes.
stat dec is more in our everyday life. So like you said, if we're making an application for a passport or signing that we weren't the ones driving or something, it's a
Yes.
stat dec. But
Yes.
affidavit is usually court.
Yes.
Okay. Thanks. And a subpoena and summons? I don't think we've got summons on this page. What's the difference between a subpoena and a summons?
Subpoena is a document ordering production of documents to court or ordering a person to attend and give evidence at court. A summons can also, you can have a jury summons. You must go to court for jury service, jury duty. And I think maybe civil law uses summons more, perhaps. But I think jury summons, I think it has summons on it. I haven't been on a jury, so I actually don't know, but I think it sounds familiar, jury summons.
Thanks, Helen. Okay. All right. Next, we are looking at specific types of offences. So we might just do a couple of these and then have a very quick break.
So murder, I've touched on this. It is intention to kill or to cause grievous bodily harm, which is really serious injury. So intention to kill or cause really serious injury. It can also be committed in where there's two accused. One person may actually do the act causing death and the other person may be participating but not actually physically do it. But because you're together, the prosecution may argue that you were actively involved and helping and not stopping. So you may both be found guilty or tried for murder. Manslaughter is it's an unintentional or it's an unlawful killing. So somebody has been killed, but it may not be it's not the intention to kill or cause grievous bodily harm, but it might still be caused by an unlawful or dangerous act. It might be, example, a stab wound to the arm, which causes a blood vessel to burst and the person bleeds, but the location suggests that there might be a reason that you know, you're trying to get the other person to drop a weapon, so you stab them in the arm. You did not intend to kill them, did not intend to cause really serious injury by the one stab wound, but unfortunately the person has died, so you're guilty of manslaughter.
Helen, I'm really sorry. I'm just going to jump in here because I should have said this at the beginning of this session. We're talking about criminal law and criminal law words, and sometimes that can be quite confronting or triggering. And especially the next couple of slides, we are going to be talking about these types of offences against people, and the next slide is around sexual offences. So I just wanted to apologise for not giving that warning before. And if people want to turn off this section, come back later, you know, please feel free to do that. Look after yourselves. Thank you.
So so manslaughter is, it can also be excessive self-defense. So the person did believe that they were defending themselves, but their conduct, their response to that fear and need to defend themselves was excessive. So there's different types of manslaughter. Common assault can be verbal. It does not have to be physical to be common assault. It can be a verbal threat. I'm going to hit you. I'm going to punch you. That can be common assault. Spitting may be common assault. Actual physical hit with no injury can be common assault. It's the least serious of the assaults in penalty as well. Assault occasioning actual bodily harm or actual bodily harm, AOABH, assault occasioning actual bodily harm. That is an assault. It's a physical assault, and there may be some injury, but it's not permanent. It may be a scratch, a red mark, a bruise. It's more serious than a common assault, but it's not as serious as grievous bodily harm, which is really serious injury. So GBH, grievous bodily harm, which translates into really serious injury or very serious injury. And that can have wide interpretation. What is really serious injury? And there can be legal argument about that. Is it broken bones or not? Is it wounding with a knife or what? So what is, really serious injury, grievous bodily harm? A fray is two or more people. It's usually like a public fight. There does not have to be anybody around when that fight is taking place, but if there were people around, it would have put people in fear. So that's, even though there may be no witness to it, but the potential to cause a member of the public fear by that behavior of fighting. It doesn't have to be weapons, but it can involve weapons, and it can be 2 people or 10 people, whatever. That's an affray.
Thank you. And the word you might not be able to see on the bottom is
brawl,
but
brawl.
that's a more colloquial term.
That's right. So that's really like an affray. It's really a colloquial, common word for affray.
So now we're talking about some sexual offences, and what we're going to do is go through this slide and then we'll do another very short 5-minute break to stretch legs. Thanks, Helen.
Okay, so a lot of cases in the district court are sexual assault trials, sexual offences. So as an interpreter, a large part of your work may well be interpreting in conferences or in court for charges of this nature. If that's something that you're not comfortable with, then yeah, it really is going to be a big part of criminal law. A lot of these matters do go to trial. So sexual assault or rape, in the law changes a lot. The Crimes Act 1900, it is now 2024, and over the years the law has changed many times. And when police charge somebody, they have to charge them with the crime that was applicable at that time. And so we do have a lot of cases now that may have alleged to have happened back in the 1960s or 1970s or 1980s, when the criminal charges or the Crimes Act, the names of the charges was different. So the language has changed a lot, and so have defenses to the law have also changed. So the legislation keeps changing, and as a lawyer, I have to keep learning new things every year with this. So yes, the language can definitely change. So there might be words on that are not on here that you do hear, but this is what we'll do for today. We don't any longer use the word rape, but that is often used in the media. Certainly used to be called that historically, and by historically I mean not 2024. Sexual assault is actually, at law and in practice, broader definition than rape, and that's a good thing for protection of victims, alleged victims, because sexual assault also covers or aims to protect victims who are male as well as victims who are female, and prosecutes female offenders. Female persons can be prosecuted for sexual assault, as well as male persons can be prosecuted for sexual assault. So I just want to acknowledge there are female offenders of sexual assault, sexual offences, as well as male offenders. It used to be much more limited to prosecuting males where there was a female victim, but now it is much broader, who can be prosecuted and who is considered a potential victim. So not everyone was protected in the past by the limited language of the law or the limited mentality of the people making the laws. So sexual assault is it involves penetration of genitals, male or female genitals, and it, as I said, involves penetration. It involves penetration by a part of the body or an object. So it is much broader than the old idea or traditional sense of rape, where it was male on male perpetrator, female victim. Sexual touching, previously called indecent assault, but there are still charges that are being prosecuted as indecent assault. But sexual touching is non-consensual, so a person did not agree to this. Touching of a person's genital areas, breasts, buttocks, vagina, penis, genital areas. So that's sexual touching, non-consensual. Again, sexual assault, I should have said, is non-consensual. There's no agreement to it. Sexual act used to be called act of indecency. Now it's called sexual act, and it is usually done in the presence of another person or towards somebody. So it might involve two people making a third person, against their consent, against their will, watch a sexual act, or it might be a sexual act of masturbation in front of somebody. That's an example of sexual act. Sexual harassment is not a criminal offence, but it can certainly be a civil offence. But I would just put it there to distinguish it harassment, sexual harassment is something that would be in a civil tribunal or workplace civil lawsuit. Child protection register can be people that are convicted, found guilty or pled guilty to sexual offences against a child victim are placed on a register. The idea is to protect other children from this person, and there'll be restrictions on where the person can live, what sort of job they can do, whether they can work with children or not. So that's a consequence of a conviction for a sexual offence against a child. And by child, it's under 16. Sorry, under 16 is cannot consent. 16 is the age of consent in New South Wales. Child is still a child under 18. Aggravated, it may be aggravated. More serious is another way of looking at aggravated for various reasons. An offence may be aggravated because of the age. The person may be under 16. It may be aggravated because use of alcohol or drugs to intoxicate somebody and remove their ability to consent. It may be aggravated by the number of people involved. There might be 2 or more accused persons involved in an alleged sexual assault. That would cause it to be more serious. It's aggravated by the number of persons involved. It may be aggravated because of the alleged victim has a cognitive or mental health impairment and that the person is aware of that impairment. Age of consent, as I said, is 16 in New South Wales for boys and girls. And historical sexual abuse, I mentioned we're getting lots of cases that are decades old, 1960s, 1970s, 1980s, 1990s. So you can imagine how old some of those accused persons are. Some of them are in their 70s and 80s now, and they're going to trial, they're going to court for offences which are alleged to have occurred many decades ago.
Thanks, Helen. There's a couple of questions around the word molest. Is that more a colloquial word, not in our
It does
Crimes
come
Act?
up, not in the Crimes Act, but it does come up in the AVO on a standard condition of apprehended violence orders. You're not to molest, harass, not molest or harass. So, but in terms of molest, it's not a crime as such, but the idea of molesting is sexual interference, interference of some way, whether it's touching, whether it's sexual assault, but it's not actually, there's no actual crime of molest.
And sexual harassment is more a term we hear in context of like workplace sexual harassment
Yes.
that people can report to like Anti-Discrimination New South Wales, Fair
Yes.
Work Commission, that kind of thing.
And be a civil proceeding at a tribunal.
Yeah, thank you. I'm just going to do a super quick poll because I've just realized we've only got 30 minutes to go. Do people want a short 5-minute stretch break or do we want to keep going? If you want a break, just put yes in the chat and we'll do a super quick poll. Or if you don't want a break, if you want to keep going, just say no. And we'll just see what people come up with. But in the meantime, this little poll gives Helen a chance to stop and give your voice a break anyway. As usual with these types of things, we've got people wanting both things. So I'm going to split it down the middle and say, let's have a 2-minute break. So we're going to come back at 12:31. So we've got a very quick 2-minute break. Thanks, everyone. Hi, everyone. Sorry, I hope that was okay. It's amazing how quickly the time goes when we have 3 hours together, but we're all learning so much, and we appreciate your um, attendance and concentration. I know it's quite hard to look at a screen for so long, so thank you, everyone. But we do have still quite a lot to do, so maybe we'll just move through these next slides as quickly as we can, because I know there's some words you've asked for that we do want to get to. So we'll keep going. Thanks, Helen.
Okay, so property offences, theft, steal from person, larceny. So steal from person is like a bag snatch without, it has the same maximum penalty as robbery, 14 years maximum penalty, but this is often dealt with in the local court, dealt with summarily, where the maximum penalty that the magistrate can give is 2 years maximum, and it doesn't have the level of violence that a robbery has, even though it's still awful for the victim. But there may not be a threat accompanying it. Maybe nothing is said, the bag is snatched, that sort of thing. Larceny, there's different types of larceny. If you go and look at the Crimes Act, there's a whole range of types of larceny, larceny by a clerk, or all sorts, and the maximum penalty is 5 years imprisonment. Stealing, shoplifting, they're all types of larcenies, but shoplifting, again, will be dealt with in the local court, and there's different different objective seriousnesses depending how much is taken, what is stolen, that sort of thing. Robbery, again, robbery itself without a weapon is there's a threat of violence or an actual or threatened violence in a robbery, and that intention to deprive the person of the property that is taken, or the shop, deprive the shop. The robbery and steal from person can now both be done in the local court. It used to be that robbery could not be done in the local court, but in 2018 they changed that to try and unclog the district court, but then COVID hit, so the district court did not get unclogged at all. I just can't see the bottom after robbery. It might be robbery in company. I just can't see the actual word. Okay.
Yeah, robbery.
Robbery in company, more than one person committing a robbery. Might be 2 people, 3 people, 4 people. And when you do things in company, you get blamed for the actions of the other person if it was sort of arguably in your ability to foresee that that person may well have done that. It may not be a verbal agreement to go and rob somebody, but you haven't withdrawn and you've certainly participated. And the lookout, the getaway driver in the car, will be equally as guilty of the robbery as the people that go in and do the robbery. But on sentence, the role of each individual will be taken into account. Burglary, sorry.
Oh, sorry, Helen. Just to clarify, would you say larceny is another word for stealing? Somebody just wants clarification around larceny.
I would say so. You often have break, enter, and steal, or break, enter with intent to commit a serious indictable offence, i.e., that is larceny. And so the actual legal type, it's stealing something. Larceny carries a maximum penalty of 5 years, so it is a serious indictable offence. Indictable offence is a maximum of 2 years, but larceny, a serious indictable offence, is 5 years maximum, which is, there's a lot of things in the Crimes Act which are serious indictable offences, because 5 years and up covers a lot of crimes in the Crimes Act. Burglary, we don't use that term in New South Wales anymore. Maybe it used to be. Break, enter, and steal. Somewhere I read that maybe burglary used to be the offence for when something was done at night time. I'm not sure if that's still the case, but other states may still use that. Break, enter, and steal can be any time of day. And another word is break, enter, and commit serious indictable offence, which could be larceny, which could be it could be sexual assault, it could be murder. But the most common of those is break, enter, and steal. Break, enter, and commit serious indictable offence being larceny, so something stolen from the property. Fraud, various types of fraud: fraud against Centrelink, fraud against the tax department, fraud using somebody else's credit card, fraud forging documents, many types of frauds. They can be Commonwealth and state-based frauds. Obtain benefit by deception. Again, that's a fraud type offence, and stealing and using somebody's credit card is a benefit by deception. But there can also be other types of gaining benefit by deception, pretending to be somebody else, that sort of thing, to fool an organisation or another person to give you money, something like that. Trespass is a fine-only offence for trespass. It's entering a place and refusing to leave when being asked. Trespass can only get a fine for that. Entering closed lands, again, it's only a fine. Offences which involve alcohol or drugs. So there's many driving offences, under the influence of alcohol or drugs, prescribed concentration of alcohol, low range, middle range, high range. I don't usually deal with these because these will be finalised in the local court, and unless it's high range drink driving, especially if there's more than one offence in the last 5 years, and there's wet weather conditions and an accident, the chance of going to jail for this is low. So legal aid will not, under policy, will not normally represent somebody if the chance of going to jail is low or not at all. But high range drink driving, of course it's serious, of course it puts everybody else on the road at risk, and it's inherently dangerous, and that one people do go to jail for that, especially if there's an accident involved. Illicit drug, there's a whole list, it's a whole schedule of drugs, both prescription and illegal drugs. There's a schedule on the Drug Misuse and Trafficking Act, and all their chemical names. So there are the street names, but then there are many drugs like ecstasy or methamphetamine, which have their chemical names on those schedules. So, and each drug will have, the law has a different weight, like what is considered a small quantity of marijuana will be different to what is the weight will be considered different to what is considered a small quantity of cocaine, or trafficable quantity can be kept in the local court, but the threshold, the weight or the dosage, if it's a liquid, will be different depending on which drug it is. Large commercial quantity of a drug carries life imprisonment. So manufacturing large commercial quantity, importing large commercial quantity, supplying large commercial quantity will carry life imprisonment. Possession of drugs is illegal, but using drugs is not. So people that are found in possession of the drug can get a conviction for that. That's usually dealt with in the local court, and a maximum of 2 years imprisonment. But if somebody's caught in the act of using a drug, then that's not actually a criminal charge to use a drug. Supply or deemed supply. Supplying drugs is considered more serious than possessing the drug. But if somebody is in possession of a drug, for example, cannabis or marijuana, which the police deem or the law deems or considers to be more than what a person could use for their own personal use, then they are deemed to be in the possession of that drug for the purpose of supplying that drug. So again, you look at the schedule in the Drug Misuse and Trafficking Act, and if something is above the indictable quantity, so small quantity, trafficable quantity, indictable quantity, commercial quantity, large commercial quantity, there are these columns in this document in the schedule. If you're above the indictable quantity, then it is deemed by law that you are in possession not for personal use, but for supplying it. It's a defense to the charge of deemed supply if you can argue that actually that amount of drug is something I'm personally using. I'm not selling it, I'm not sharing it. And at law, sharing a drug is equal to supplying the drug. Even if you're not receiving any money for it, sharing an illegal drug or prescription drug that is not prescribed for somebody else, that is a supply. But when you're sentenced, it is considered less serious if it's shared than if you're making lots of money out of that. So deemed supply and possession will go hand in hand. So you might be charged with possession and deemed supply, but you might admit guilt to possession but plead not guilty to deemed supply. Supply of drugs, the bigger the quantity, the bigger the chance of going to jail. Merit program is it's a referral program in the local court by magistrates to divert people away from jail, away from the criminal justice system. Like it's a magistrate's early referral intervention for intervention and treatment, something like that. And it's to get the person go into a program, come back successfully, hopefully, and get sentenced for that. So then we have domestic and family violence.
Do you want me to go through some of these, give you a bit of a break? We don't have any questions about the drug offences, so we will go on to this. So just very quickly, I guess this is another area that would be quite common for you to encounter in the local court. Some local courts have like domestic violence list days where there's a lot of these matters. So I've just put some acronyms there first. You might see or hear DV, which stands for domestic violence, but some people might say DV. FV would stand for family violence, or sometimes you might see DFV, so domestic or family violence. Usually in the New South Wales laws, it's called domestic violence, but in the Family Law Act, which is Commonwealth or federal law, it's generally called family violence. There might be some small differences, but generally it means the same thing. DVEC, was that one of the questions people wanted to, so that stands for domestic violence evidence in chief, I think. Is that the video, the body worn cameras from the police wear?
Yes. So it's, yes, audio, video. It may be audio recorded, not video recorded, or it might be video and audio recorded, and it's the alleged victim's version of events, and that becomes their evidence.
So that might be something you hear, an acronym you hear in court. Another acronym you might hear is PINOP, which stands for Person in Need of Protection. So in this case of AVOs or apprehended violence orders, the person who's being protected by that is called the PINOP. And so AVOs in New South Wales, they're called apprehended violence orders, and that can be domestic. So if the other person is related to you or a carer, so in a domestic relationship, it's a domestic violence order. And personal violence order, a PVO, is, I guess the common examples are if there's somebody needs to be protected from a neighbour or a colleague or something like that. So it's someone you're not related to, but you can still go to court to apply for an AVO. We talked a little bit about this before, about consent without admissions. So the person who's having the AVO the defendant in the AVO, they can say, I agree to the AVO without admissions. So they're not admitting that they did the things that are written in the AVO application, but they can agree to that order. One of the reasons I'm explaining this slide is because AVOs are one of those areas that's sort of in between what we call civil law and criminal law. It's not a crime. So if somebody has an AVO made against them, it's not a criminal matter, but it only becomes a criminal matter if they breach the AVO. So the person will have these conditions in the AVO that they can't do. So they can be there's a list of 3 sort of mandatory conditions that all AVOs have. You can't assault, threaten, harass, intimidate, that kind of thing. And then there's some other conditions that could be you can't contact the person at all. You can't go within 100 meters of their house. It's all this big list of other types of conditions. And if somebody does one of those things, that's a breach. And then that becomes a criminal charge. And AVOs can also be provisional. So that's like before it goes to court. Once it goes to court, it could become an interim one if somebody doesn't agree to it. And there needs to be a hearing later on. There could be an interim AVO. And then a final AVO is, yes, there is an AVO in place now for 1 year or 2 years. So that's what we mean by provisional, interim, and final order. Conditions I've explained a little bit. Breach. Now, I'm going to hand to Helen now. So there's a new law that you all will probably come across in court. So it's a new law that's starting on Monday, on the 1st of July in New South Wales, and it's to criminalise coercive control, which is a type of domestic violence offence. So I'm going to hand back to Helen to explain that. So firstly, we should also say some of you would do interpreting work in other states and territories. So all of them have a similar, what we call AVO in New South Wales, but it might be like an intervention order in other states or a restraining order. There's other names for them, but it's, basically a similar thing. And they're recognised in other states. So if somebody has an AVO made in New South Wales, they can't go to another state and do the thing. They're still apply in all the states and territories. So Helen, I'm just going to ask you to explain a little bit about this coercive control, and I'll say that you will all get an email after the webinar, which will have links in it, and we'll give you links to lots more information about coercive control, because I know people are very interested in this and it's a new law. So we'll have some links to some resources, videos, podcasts, that kind of thing. But thanks, Helen. I'll hand back to you now.
Thank you. So I have to learn all of this myself as well, with the law starting on the 1st of July. And I myself have listened to the Legal Aid New South Wales criminal law podcasts on Podbean. There's several short audio recordings, podcasts, which I found very helpful explaining this. Essentially, coercive control is a series of conduct or series of events which is aimed at controlling a person in the domestic relationship, a partner or an ex-partner. It does not need to be physical to be coercive control. It might be emotional, psychological, and physical, or it might it's behaviors over time. It's not one-off event. And it may be a combination of behaviours. For example, and by no means the list is not exhaustive, it might be controlling somebody's whether they can work or not. It might be putting pressure on somebody to quit their job and stay home as a means of controlling that person's ability to interact with people outside the home. That might be one way. It might be financial abuse or financial control, controlling the access that that person has to their own income, the family income, that sort of thing, limiting their ability to make transactions. It may be monitoring their phone calls and text messages. It may be putting a tracker or a GPS tracker on their car, that sort of thing, stalking them. At at present, there is a stalking charge, there is common assault, there is those sorts of charges, but there's no charge against somebody for deliberately limiting somebody's access to money for the purpose of controlling that person. And there's another form of coercive control, might be isolating a person from friends and family. And that may take time to do, but eventually their communication is cut off and they're no longer socializing with family and friends. So that may be building up over time. A course of conduct, that's really what coercive control is about. So now we have sentencing discounts. So this applies to really jail sentences, prison sentences. But if you're interpreting in a conference while the person is with their lawyer still in the local court, the lawyer will have to talk about this. And it's compulsory as lawyers that we do talk about it. So you might hear the lawyer telling their client that if they plead guilty to a charge in the local court, they are eligible for 25% discount off the sentence. If they're pleading guilty to the charge after it's left the local court and it's already reached the district court or the Supreme Court, but it's before the trial, and it's 14 days before the trial date, then the most they can get discount-wise is 10% discount off the sentence. If they plead guilty either on the day of the trial or less than 2 weeks before the trial, less than 14 days before the trial, then the most discount they can get is 5% discount off sentence. Now, as a lawyer, we must tell our clients this, but it can be an awkward conversation. Some clients are not interested in pleading guilty, and that's fine. So I try to balance it. So not trying to pressure somebody to plead guilty, not suggesting they should, or I think they should plead guilty, but I at law must explain this to them because we have to sign a document also saying that we have explained it and that they have to sign saying their lawyer has explained the discounts available for what's considered an early plea of guilty if it's done in the local court. Types of sentences. So the worst that you can get is full-time prison, meaning you're locked up in custody at a jail anywhere around the state of New South Wales. Sentence of imprisonment is served usually partly in the prison and partly in the community on parole supervision. But you have to still behave on parole, because if you commit a new offence, if you don't go to the meetings, if you fail a drug test, don't follow all the rules, then the parole board can issue a warrant for your arrest and you can be arrested by police and taken back to jail. So there are serious consequences for breaching the rules on parole. A life sentence in New South Wales means life in jail, never to be released. The person will die in jail. It never used to be that way, but it has been that way for a while now in New South Wales. The next worst is intensive correction order, or ICO. This is a sentence of imprisonment. It is a prison sentence, but it's served in the community under strict conditions, including supervision by the parole officer. And if a person breaks any rule, they'll be reported, can be reported by their parole officer, and the parole board can decide to revoke or cancel the intensive correction order, issue a warrant for their arrest, and bring them back to jail. And then it will be decided, is there 1 year remaining on this intensive correction order? Is there 4 months remaining? They'll be serving the time in jail. They may be able to have it reinstated. One thing I find a little bit unfair, well, quite a lot unfair, is that sometimes when somebody is simply accused or charged of committing an offence while on an intensive correction order, the parole officer writes a report and the intensive correction order is automatically revoked. And despite the fact they haven't yet pled guilty or been found guilty of the new offence. So I find that the parole authority presumes guilty a bit too quickly. But those intensive correction orders can be reinstated after a period of time. So, but it is a sentence of imprisonment. The maximum of that type of sentence is 2 years if it's one charge, or 3 years if it's more than one charge. So a combination of 2 charges or 3 charges or 4 charges, whatever. They can be handed out in the local court or district court or Supreme Court. But dare I say, Supreme Court would be quite rare when we're talking about murder or terrorism or big tax frauds. Community correction order or CCO is a non-jail sentence. It is not jail, it's non-custodial order. It does carry a conviction. It is on the criminal record. It's like a good behaviour bond, and there may be conditions of supervision or not. It can be a 3-year maximum. Must be good behaviour, not get into any more trouble. If you do get into trouble, then you get brought back to court. So you don't go in front of the parole board, but you do get brought back to the court that gave you that order, and you may be faced resentencing. So you may get a worse sentence. You may go to jail if the court thinks that you've broken the rule or broken too many of the rules. So community correction order, you can get breached for not following the rules. The rules might be don't take drugs, don't drink alcohol, don't commit a new offence. Can be a whole range of rules involved, and the court will impose conditions when they make that order. Conditional release order, CRO, again, it's not jail. Again, it's like a good behaviour bond, but it's considered for less serious offences, so more likely to be given in the local court than the district court. Not impossible to get it in the district court, but this would be more common in the local court. Again, there are conditions. May or may not be supervision, but there may be don't take drugs, don't drink alcohol. Depends on what the charge was about, depends on what that person's personal background is about. If they were on drugs when they committed an offence, then it might be a condition not to take drugs, for example. Fine. A fine can be imposed by a magistrate or a judge. Usually, if you're just going to get a fine, district court be quite rare to, because district court deals with more serious things, rare to get just a fine. This would be more common in the local court. Possession of drugs might result in a fine. Larceny might result in a fine or jail, but you maybe just get a fine. Section 10, subsection 1A, this is where the charge is dismissed and there's no criminal conviction. So this is usually reserved for somebody who's first time before the court or haven't been before the court for quite a long time, and they've got very good criminal history or nothing much on their criminal history, or what the court considers extremely low level offending. You can't keep getting this penalty. Like if you keep coming back, another offence, another crime, you're going to run out of chances of getting this.
So Helen, I'm very conscious of the time. We are just on 1 o'clock, and I guess some people probably do have to leave. but there are quite a few questions about sentences. We've got a little bit more to go. We might just keep going for another 5 or 10 minutes. And if people do have to leave now, you will get a link to the recording, so you can always catch up on the last few minutes. So I think we'll just try and finish off, Helen, if that's all right, if you've got
That's
10
fine.
minutes.
Yep.
And apologies for going over time too. So questions about sentencing is, so my internet connection is a bit unstable at the moment apparently, but hopefully you can still hear me.
Yes, can. Okay, I think Natalie has lost the internet connection. I can no longer see the slides for Natalie. Okay, Natalie's back, I think. You're back. You're on mute.
Sorry about that. My whole thing just dropped out.
No, that's okay. I realized I couldn't see the slides anymore, so I couldn't see. I wasn't sure what.
I think we're still sharing the slides.
Yep, now the slides are back.
And I think some people have dropped out with that tech issue. So we'll just keep going.
I can see some of the questions.
You might have to go through those because I've just
yeah, that's all right.
Quickly lost
them. Offering a discount in sentencing is different to inducing or an inducement. An inducement, when they're talking about inducement, that's something that the police check if somebody has been offered a promise or an inducement or a special deal to give an interview with police. But that's different to being the court giving a discount. The discounts are mandatory in the legislation. So the Crime Sentencing Procedure Act has these discounts at a particular time stipulated in the legislation. They never used to be stipulated in the legislation before 2018. It used to be discretionary up to the judge or the magistrate as to how much discount would be given for a plea of guilty and when that plea of guilty was entered. But because of the backlog in the District Court, New South Wales, waiting time for people to have trials, and the belief that people would wait to the last minute to plead guilty, and they tried to encourage people to plead guilty earlier while the matter's in the local court. And traditionally, judges would be giving discount of 25% if you pled guilty in the local court. So it's really enshrined what the practice was, and maybe that's that bit more common law and what the traditional practice of courts was, and now it's in the statute. But what has changed is judges no longer have the choice to give somebody 20% or 15%. Those numbers are gone. There's no discretion now for the judge to give somebody a 20% or a 15% discount if they plead guilty after it's gone to the district or Supreme Court. So the judges have less choice, but there is certainly more certainty when we advise clients, but it's not an inducement, different thing. ICO, intensive correction order, is different from parole, but you are supervised by the same department. Intensive correction order is a sentence of prison served in the community, whereas parole is the end of a sentence where you started in jail serving that sentence, then you're released on parole and supervised in the community. So they are different. Intensive correction order is fully served in the community. There is no non-parole period in jail for the part of the sentence. Section 10(1)(a) is different from an acquittal. An acquittal is when you're found not guilty. A Section 10(1)(a), there is a plea of guilty. The person has admitted their guilt, but there's no conviction recorded for it. And that result might help somebody that wants to apply for traveling overseas, applying for a visa or something like that, or a job interview where difference between conviction or no conviction. In New South Wales, the local court is the magistrate's court, but we call it local court. The magistrate presides over that. Other jurisdictions, I'm not sure, and I think Victoria's county court. And home detention does happen in Australia, but it's in 2018, they changed it from a standalone by itself type of sentence to a possible order or possible condition of an intensive correction order. It can only be made if the Community Corrections Department, which is a section of corrective services, write in their sentence assessment report that you are suitable for home detention. And it cannot be for certain domestic violence offences. And they go to the home, they look at the suitability, who is living with this person. So certain offences will not be suitable for a home detention, and it is monitored by corrective services. The ankle bracelet is put on and funded by corrective services, but you can't just apply for it on its own. It is only if you're suitable for it and it's part of an intensive correction order. And
You have answered all the questions. I just skipped the slide before because I think you had answered the non-parole period and things already. I might also leave this slide, so around mental health issues, unless there's particular things you wanted to explain, Helen. We actually are having another webinar for interpreters on civil law words, including someone from our mental health advocacy service. So we'll include the details for that webinar in the email you'll get, so we can talk more have more time to talk about these issues.
Because we do have people that go through the criminal system who are unfit because of their mental health or their cognitive impairment issues. So I totally recommend, if as an interpreter, this will come up. So I totally recommend attending that session as well. And this is a big part of criminal law, and this is where criminal law and civil law join.
Definitely. So I apologize for that. And we like to do a section on some American words that you will hear a lot, especially if you watch American crime shows and police shows, but that we don't. So you might hear people say these words a lot, but we don't use them in Australia or in New South Wales. So do you want to just quickly go through those, Helen?
So misdemeanor, we don't use it, but I think it's less serious. I think it's more like our summary offences. First and second degree murder, we don't use that phrasing. We have murder and we have manslaughter, and that's different intentions, different mens rea. Early release for good behaviour, we do not have that. Your non-parole period is the minimum time that you will do in jail on a jail sentence. You don't get let out earlier if you're of good behaviour in prison. So that's a bit of a difference between some, not just American, but some other countries. And plea bargain, it does get used, but we don't actually, we negotiate, we call it negotiating, but we don't actually call it plea bargain. I don't, and certainly we don't make a deal with the prosecution about, well, if he pleads guilty, that they will agree to 2 years in prison. We have no say, the lawyers have no guarantees or promises about what sentence the person will get. That is completely up to the court, up to the judge, up to the magistrate. We cannot make a deal with the prosecution. I cannot guarantee my client what result they're going to get.
Thank you. All right. So that brings us basically to the end of the session. So thank you so much, Helen. I've just got on the screen here where to go for more information. I know some of you were asking in the chat about resources. So if you look at the Legal Aid New South Wales website I mentioned before, there's a section on community legal education. And if you go to that, so ways to get help, community legal education, that's where you'll be able to register for the next webinar I talked about on civil law words and any other webinars coming up, or other training. So please do have a look at that. And there's other links to resources, particularly about the coercive control, we will put in the email that you'll get afterwards, and some other glossaries and things about legal words. So thank you very much, Helen, for your time, and for everyone. I know 3 hours on a screen is a lot.
Thanks to everybody for joining us and participating, and we just we hope that it's useful and interesting and something new maybe for some people.
Yeah, I think there's new words we learn, including I learn every time we do this. So thanks, Helen. Thank you, everyone.
There's always good questions. So thanks for the questions, because it also helps us know what you want to know, and then we can also tailor it for future as well as answering it the best we can on the spot.
I will just, I'll just leave on the screen there. If anyone's got some last minute questions, do feel free to add those in. Helen, I'm not sure if we can answer this question or if we need to do a bit of research, but so a couple of questions that came before was, have you heard of the term a straight sentence? Is that something we use in New South Wales?
No, I haven't. No, I haven't heard that.
No.
The only thing I could think possibly a fixed term, meaning 6 months fixed term, that's 6 months in jail. There's no non-parole period and parole period, or you're going to do 6 months. Fixed term, but I haven't heard of a straight sentence. I apologize. No.
And the other question was, Helen, I'm not sure how much experience you have had with clients who are deaf. And one of the Auslan interpreters has asked if there's something called language deprivation syndrome, and wondering if that's something they've noticed as an interpreter, how or when to raise that. I said, I
haven't. I have not represented a client who is deaf, or a client. I have not actually represented a client using Auslan either. There are hearing loops in court for jurors and accused, but I personally have not actually represented somebody who required an Auslan interpreter yet.
So that might be something we get back to you about if you're still online, the person who asked that question. All right, let me just check the chat once again for any final questions while you're still here. Somebody said interpreters also use hearing loops, so that's a good point.
And sometimes the whole jury does, when there's recordings and things that may be hard for everybody to hear as well, like audio recordings and things like that, phone calls and things.
Yeah. Great. Otherwise, I don't think there's any other questions. Just lots of people saying thank you.
Well, thank you all.
We'll let you all get on with your day, and thank you again for joining us.
Thanks, Natalie. Thank you, everybody.